All right, thank you for staying with us. The conversation right now, as I said, is about the rule of law and where does this put us? Not just about the rule of law, having strengthened and a solid institution that can withstand any pressure. And you might want to ask me, why is there, a template? Is the unceremonious removal of the former CJN, my Lord Justice Walter Onnoghen, retired. You know what happened under the leadership of the tenure of President Muhammadu Buhari, and how he, Walter Onnoghen, Justice Walter Onnoghen, was a CJN there. And all of a sudden, there was a case against him by the Code of Conduct Bureau led by Danladi Umar then. Forced declaration of assets and, some things that were said that he did, some huge amount of money found in his possession that he couldn't respond to. And these are some of the allegations against him. And not just about that, it was the way the investigation, if you can call that an investigation, was conducted. It was so fast, looking scripted, and many Nigerians raised eyebrow to say, what is really going on? And before you say Jack Robinson, he has been suspended, removed, and Justice Tanko took over, after him. After Justice Tanko, we've had Justice Olukayode Ariwola, and now my Lord Kekerekun in charge of the judiciary. I'm talking about nationally in Nigeria. But then the man didn't just stand down. Talking about the former Chief Justice of Nigeria, Justice Walter Onnoghen, he appealed the matter, and the Court of Appeal, Abuja Division, on Monday, that's 2 days ago, overturned the conviction, of the Danladi, Umar Danladi Tribunal, CCT then, Code of Conduct Tribunal, and led by Danladi Umar, the conviction that he made on Walter Onnoghen, and that conviction was overturned, which found Justice Walter Onnoghen not guilty. Some of those things included guilty of false asset declaration. You know what happens when you are going into public office. Now, the appellate court in a judgment discharged and acquitted Justice Onnoghen from the conviction delivered against him by the CCT, and this conviction, which was delivered on April 18, 2019, was dismissed following the resolution of the issues that led to his trial and conviction. Justice Abba Mohammed, who predicated the judgment on the terms of settlement by the federal government, and Onnoghen ordered that the 4 bank accounts previously ordered to be forfeited be returned to him. Many things that have happened in that. We had, of course, settlement because he went to court. This is what we are having. Finally, he has been acquitted and say he has nothing wrong that he has done. Now, we want to speak to the issues. How does that make us? Because the optics looked very bad at that time, and it even tore lawyers apart. Many NLC spoke on the matter. Yes, he's guilty, he's not guilty, but the version, just like I said, in which all those things was done, was what begat that question until now. We'll be speaking at this fancy stands with our first guest on the program, Agih Sylvester Isaac. He's a lawyer and, of course, senior legal analyst at the Citizens Gavel. He joins us virtually. Good morning, Barrister Agih.
Good morning. Thank you for having me.
All right. Very well. I'm sure you follow this case and you had my introduction. What was your impression of this latest development? He was unceremoniously removed in office. Talking about Justice Walter Onnoghen retired. And just 2 days ago, after years of litigation, he has been acquitted of any wrongdoing. But then he can never get that position back. But before we get into the nitty-gritty, what's your impression of the whole matter till Monday?
All right. Thank you so much for the question. The news actually came to me with a mixed feelings, right? So on the one hand, some would say, "Oh, that's a win for democracy," and on the other hand, I personally have some questions, right? For instance, in the course of your introduction, you mentioned the fact that certain allegations were levied on him or leveled on the past CJN, and they have to do with the fact that he failed to declare some of his assets. in his asset declaration forms, and some others he was accused of not improperly declaring them. Basically, there were 6 charges against him before the Code of Conduct Tribunal. And then in 2019, of course, that charge was preferred against him before the Code of Conduct Tribunal, and he was arraigned before the court. But interestingly, this came shortly before the 2019 general election, right? So there were so many speculations around the issue. Some people thought that, look, that was President Buhari, trying to position himself in such a way that when he wins the election, quote unquote, and there is an election petition against him, he wants someone that would, tilt his weight. That was one side of the equation. Other people are looking at it that, look, the law is the law, right? That once you flout the law, regardless of who you are, you ought to go in for it. And so, having discovered that, and don't forget, that was actually according to the report. I don't know this for a fact, but that was actually a purported petition, against the CJN, saying that, look, he failed to comply with the Code of Conduct for public officers in terms of those declarations that are made against it. So it was premised on that he was charged before the Code of Conduct Tribunal. Now, like I said, somewhere of the view that, look, if he actually flouted the law, then he ought to go in for it, right? Others were saying that, no, the timing was absolutely off, and that it is possible that was President Buhari as again trying to, like I said, position himself, right? So, well, what happened was that the Onnoghen was removed from his position. Now, there was a debate during that period whether he was merely suspended or removed, right? By law, it is the agency that ordinarily ought to have discipline. In fact, any judge, not just Onnoghen, right? But of course, Onnoghen is viewed there. So let's look at it. Now, ordinarily, the agency ought to have investigated him first, found that he was actually guilty of what he was accused of, and then, issue or sanction him, basically. Right? That is how the procedure ought to be. And then, if there is need for him to be removed, at that point, the agency would have made the recommendation that, look, Mr. President, we are hereby recommending that this man be removed based on ABCD. And then, even at that, the Senate, 2/3 of the Senate, ought to have issued an address, supporting that motion before Onnoghen can be formally removed or even suspended. That ought to have been the procedure. Right? But what we saw was an absolute, it was something strange, basically. It was something strange because what happened was that the chairman of the Code of Conduct Tribunal purportedly issued an order ex parte, right, asking the CJN to step aside, quote unquote, and then, allow someone else to fill in the space pending the determination of his contract before the Code of Conduct Tribunal. Now, like I said, that is a totally strange procedure in our laws, right? But of course, that was what happened. Now, like I said, there were arguments as to whether it was a suspension or removal. Now, if it were a suspension, okay, so the federal government argued that it was merely a suspension, it wasn't a removal, so they ought not to comply with those provisions of the law that I mentioned in terms of going to the NJC and then having the Senate, giving their support or confirming the proposition and all that. They said it was just removal. But long and short of it, he was out of the office, right? Now, he went through the trial. Now, there's an interesting angle to this. Prior to his trial, there was another judge, one in Gajua or something like that, that was equally accused of a similar, though his has to do with corruption and, of course, flouting the provisions of the Code of Conduct for public officers. And there was a case at the regular court and then one at the the Code of Conduct Tribunal. And what happened is that at the Court of Appeal level, the court ruled that, look, you cannot try this person in any court or before any authority at all until the agency has made a formal pronouncement as to the status of whatever offense you have against the person, right? Now, this person, on that basis, the charge against him before the regular court was dismissed, or rather, it was struck out, and then the one before the Code of Conduct was also struck out, right? So that was like a precedent as far as that issue was concerned. So Onnoghen went before the Code of Conduct with some form of confidence that, look, since there is interestingly, it was the same Umar Danladi's this thing that actually discharged this other judge that I just mentioned, right? So When Onnoghen went before him, there was this confidence that, well, to some extent, and since there was a precedent already, in place, that he would be acquitted, not acquitted, but discharged at least, pending when the agency would have given its verdict as to whether or not he has something to answer. So, but the legal profession, I would say, we were taken by surprise when eventually we heard the news that Onnoghen was convicted, right, by the Code of Conduct Tribunal. And of course, he had to challenge the position. So he did in 2019. Interestingly, it took about 5 years before there was some form of closure for him, right? Because from 2019 till date, it's about 5 years. And that tells you how slow our justice system is. If for a one-time CJN, if it took him that long, to come to a head as to his case, you can imagine what a regular citizen goes through in court, every day. So it was a sad one, it was a sad one. But I have some issues, like I said. The news came to me, with mixed feelings because, firstly, the proceedings before the Code of Conduct Tribunal, is passive criminal in nature. In fact, we could say it's criminal because a person brought before the tribunal would be arraigned. He or she would take their plea. They would be they will go through the trial procedure. And then if the court finds them guilty, they'll be convicted. So that's more like a criminal action. So the practice of, parties now coming to enter into what is called terms of settlement. Honestly, it is strange for a criminal proceeding. I'm hearing that for the first time, but of course we learn on the job. So I'm assuming that maybe this is me learning for the first time. But it's totally strange as far as my knowledge of the law is concerned. Parties do not. Yes, please.
Yeah, Evelyn.
All right, so Barrister Agih, you stated that the Code of Conduct Tribunal, the CCT, lacked jurisdiction to try and convict Onnoghen in the first place, and it took 5 years for this particular judgment to be obtained. You have said is justice delayed. But then there are people who bring up the speculations or the conspiracy theory that do you think this delayed justice had anything to do with the administration of President Muhammadu Buhari? Some people think it's the dislike or an issue President Muhammadu Buhari has or had for former CJN Walter Onnoghen that made that particular issue not to be resolved during his administration? Or is it just a mere coincidence that in an administration of President Bola Ahmed Tinubu, the case was upturned, the judgment rather was upturned, and it was said to go and be settled out of court?
Okay, so, and this is my personal opinion, I think that his removal has something to do with the 2019 elections, and then that the impression that I have is that the CJN at the time was not probably suitable as far as the what do you call it, the plans of the then president was concerned. He was not the position he occupies. It's such that the president might lose at the tribunal if eventually his election is valid. I feel that was why he was removed, and I will tell you why. Now, when immediately he was removed from office, the second in command, that is Tanko Mohammed, was sworn in as the acting what do you call it, as the acting CJN then. Right. And yeah, so what happened then was that almost immediately after the elections were concluded and Buhari was declared as the winner, of course, naturally, Atiku went to court, and at the tribunal, which is the Court of Appeal, sitting as the Presidential Election Petition Court, dismissed the petition of Atiku, right? So Atiku had to appeal to the Supreme Court. Now, naturally, Supreme Court is the last court, right? And whatever it says stands. Now, Buhari needed someone that would actually make a pronouncement that favors him. And I believe that was why he brought the Tanko in. Now, let me tell you why I said that. Now, when Tanko came in, what happened was that upon hearing the appeal, now this is the way an appeal works. When parties, transmit their, evidence, the evidence that was led at the lower court, among other things, when they are transmitted, what is done is that a date is given for the hearing of the appeal. Now, at the hearing of the appeal, parties are expected to adopt their briefs of argument, right? When they adopt this, usually the court will adjourn. And when they adjourn, theirs is to go and consider the evidence presented as well as the argument, canvassed by the parties, and then come to a conclusion as to what they decide, whether in favor of the person that appeals or not. That is how the procedure works. But what Tanko did was that on the same day that parties adopted their briefs of argument, on that same day that parties argued their case, Tanko and his team went into the chambers, took a short recess, and came back and then delivered judgment. And in the judgment, they simply dismissed the petition of the article. But because there was no time for them to give reasons, because so it came to me as a decision that they just took, and they needed time, of course, naturally, to give reasons. So they said they adjourned the matter to say that, look, we'll give our reasons at the later date. And that was what happened. They didn't give their reason for dismissing the appeal on that same day that arguments were heard, until a later date that they now came and they say, oh, part of the things that you alleged was that INEC had this thing, what do you call it, server, and then that from the evidence, INEC said it never had a server, among other things, and that was it. That was it. So, given all this, and like I said, it was a strange procedure, right? Because ordinarily, yes, they ought to have. Yes, they could decide to give judgment on that, but it was totally strange, especially for that kind of matter. There are certain matters that you take your time to look at the evidence, what was presented by the parties, what was argued by the parties, and then you make an informed decision. But in this case, it was totally, it was rushed through the same way that Onnoghen was removed from office, in a very strange manner. That was the same way the judgment of the court eventually was given in respect of the petition filed by article. And so that is why I feel that, in fact, the removal of Onnoghen has to do with the 2019 election. They needed to put him aside to get someone that would rule in their favor. And then, of course, whatever happens afterwards, it's basically too late, right? Onnoghen cannot come back to redo what Tanko has done, right? And, of course, what do you call it? Buhari has done his 2 terms and he has gone. So, generally, they have no use for him or any need to further, what do you call it, prosecute him. And I believe that is why they thought that, look, let's just go into this terms of settlement and just let bygone be bygone.
All right. Yes, we understand we are being joined on this program by our second guest. He is a lawyer as well. He joins us virtually from the U.S., Agih Sylvester. If you can hear me, good morning. Thank you for joining us.
Good morning, Femi.
All right, and Barrister Agih, kindly hang in there. We'll be with you shortly. Now, let me speak with Jacob, Barrister Sule, by the way. This is where we are right now, 2019 to 2024, 5 years of the conviction, of the CCT, then led by Danladi Umar, Code of Conduct Tribunal, against former CJN Onnoghen, retired, was upturned 2 days ago, and the man was freed of any wrongdoing. But just like Barrister Agih have been positing for us, many persons believed at the time that it was not just about doing things right. It was not just about him declaring a false asset or something. And even if that is the case, that is a turn it will have taken. The NJC could have played a part in all of that. But the way and manner his removal, came, raised many eyebrow. And 2 days ago, that was put to rest. So, in all of these, 5 years down the line, what's your impression so far? Let's start from there.
Thank you very much, Femi, and good morning to everyone listening and the good people of Osun State.
Thank you very much.
I want to lend my voice to this conversation by saying that there are a lot of technicalities that needs to be considered as regards to the removal of the former CJN Justice Walter Onnoghen. There needs to be a basis for this conversation, so those who are probably just following up would actually know where we started from. Former President Muhammadu Buhari in 2019 removed the CJN from office, following a charge that was levied against him that was budging on forced declaration of assets, where the Code of Conduct Tribunal had then found him guilty. However, we saw the deliberate and flagrant disregard of the provisions of the law as regards the removal of a judicial officer by the president himself. And this calls for a lot of reflection for us as a country, as a nation, on where Nigeria is headed to. Legally, Section 292 of the Constitution of the Federal Republic of Nigeria states clearly that the powers to remove a person from the courts lies with the National Judicial Council. But unfortunately, what we It's a total disregard for law, where supposedly the
Pastor Sule, are you with us? Okay.
to cut to the process.
All right.
And let me be
All right.
JN is removed by an ex parte order. And by practice of law, what does an ex parte order means?
Right.
When this CJN was removed, it literally meant that there was...
Okay, it's like we are losing connection from Barrister Sule's end. We'll try and fix that. Barrister Agih, are you with us? Okay, all right. We'll try and fix that, and we'll get back to the gentleman. Actually, many things have been said here, Evelyn, about that. Okay, if actually the allegations against him even has substance, there is a way it could have gone at that time. The NJC has a part, or we always have a part to play in the submission of names, endorsement of a particular justice for a particular rule, or even punishment or dismissal of such officer, judicial officer. But that didn't quite follow that particular provision as at that time, because it was even, sometimes it looks like these things happen very fastly. 5 years ago, it looked like yesterday, and I remember the furore, the controversy behind that at the time. And the general, election I just held, and the case were in court, and many persons believe maybe there are sinister motives by the government of the day to have their own, in the house. And these are some of the issues, and these. That's why these conversations predicated on the rule of law and having solid institutions that can withstand any pressure from anybody occupying any space.
Yeah, and we should also speak to the separation of powers, the judiciary, the executive, and the legislative. It seems in Nigeria here there has been this mashup of these different arms of government. Each one of these arm of government is supposed to be independent.
It seems they're overlapping one.
But exactly, and it seems the executive has the upper hand when it comes to more powers, deciding what the legislative will do and deciding what the judiciary will do. Like Barrister Agih said earlier on that, it's supposed to be the the NJC rather, the National Judicial Council, that's supposed to be on top of the situation. If you have any allegation against the Chief Justice of Nigeria, then you should actually write to the NJC to look into the matter, not you trying him with the CCT. It's not done anywhere. And
like any other civil servant.
You understand, and it actually speaks to the quality of our judicial system, the standard which we have. During the administration of President Muhammadu Buhari, we had a senior advocate of Nigeria as his vice president. By the way, it was Vice President Yemi Osinbajo that actually brought in, or what's the word I'm looking for now? Is it inaugurated, or Justice Walter Onnoghen before sworn in. Thank you. Sworn in Justice Walter Onnoghen. Now we had Hesse as the Vice President of Nigeria. We had Attorney General of the Federation in the person of Abubakar Malami SAN, who was supposed to have actually advised the president on the process, of laying these allegations on the Chief Justice of Nigeria. You don't just remove the CJN and put him up for trial at the Code of Conduct Bureau. It's a Code of Conduct Tribunal rather. It only speaks to when politicians really want to get what they want, they will try every and anything just to lay hands on what they want to get.
And that is very instructive. And for these, it will cement the sentiment of some persons who felt that removal was solely about, the legal fireworks at the courts then, and they just had to put him out of the way, via something. But some will say that doesn't mean that maybe there were not, that he wasn't guilty in some guys, but only that the way the case was, handled then. But then the courts have said otherwise right now. Nothing bad has been done. In fact, it's an out of court settlement kind of a thing to say, acquit him, let him go. No wrongdoing was done. But then we're trying to reestablish connection. Trust us to stay on this matter. We'll take this quick break. And when we return, hopefully the conversation will continue on Money Spring.